Unit 3, Part 4. Let's carry on. Okay, definition of a member. A member is defined in Section 1 of the Act as a person who has been enrolled or admitted as a member of a medical scheme, or who, in terms of the rules of a medical scheme, is a member of that scheme. So you see what we said before. It is a person, a natural person, not a business, who has been enrolled or admitted as a member of a medical scheme, or who, in terms of the rules of a medical scheme, is a member of that scheme. It means that only natural persons can be members. You cannot have a company, PTY, or CC, like ABC brokers. How can they be, how can a doctor check ABC brokers? Must be a natural person. So they cannot, it must be natural persons can be members of a medical scheme and not juristic persons like a company. Because the scheme rules provide for the rendering of relevant health services to a person. Once again, to a person, which involves the physical or mental examination of that person. You cannot physically or mentally examine ABC brokers or a company, XYZ Financial Services. No. So a company cannot undergo physical examination. That's why a member must be a natural person. It must be a male or a female. Now tell me, ABC brokers, is it a male or a female? XYZ Financial Services, is it a male or a female? You see the problem? All right, cool. So a member of a medical scheme is also sometimes referred to as the principal member. So the person who's the main person on that scheme, who signed the documents and who's paying for it, is the principal member, or also referred to as the main member. It's the same thing. Tomato, potato, attorney, lawyer, same thing. All right. So some people talk about the principal member and others talks about the main member. Same thing. It indicates that without a member, as defined in the Act, one cannot have a dependent. So you cannot say, no, there's no principal member or no main member. There's just two dependents. No, you must have. Let me draw a picture for you. You must have the MM, the main member. And underneath the main member comes dependents. Dependent one, your spouse, and then maybe another two. Your son is dependent two because he's the oldest, and 5 years later your daughter come, and then you add that and you become dependent three. Okay. So beneficiaries can only be registered as dependents if they are dependent on someone who is a member of the scheme. Now look at the different spelling of the two dependents. Now for you that's not English like me, there's a difference. That one is spelled with an A, and this dependent does not have an A, it has an E. The difference is a dependent is a person, like your wife, your spouse, your husband, your children, whoever it is. It's a person. Okay, it refers to that person. Dependent, it's the word. How do I say the word? You are dependent. It's like Mercedes-Benz is dependent on factory workers to put the cars together. A vehicle is dependent on tires to travel. If you want to fly, it's depending the weather to fly. You see, it's not a person. That's why the two spell differently. So I hope that makes sense. Okay. So this one, this dependent, is not a person. This is like a condition. Depending on the weather, we'll decide if you're going to play outside tomorrow or not. It's like a condition. Okay. So all your loved ones is dependents, but they all depend on you if you're going to give them pocket money or food or love. That's the difference. Okay, so beneficiary can only be registered as dependents if they are dependent on someone who is a member of the scheme. The member is the person who usually has a direct contractual relationship. So because the member is the one or she's the one that got the direct relationship with the medical scheme, because they completed the forms as the principal or main member, they are paying for it. While the dependents may not have a contractual relationship, they haven't signed any documents, they are not paying for it. They just like piggy bank on the main member. But obviously, if it's your children, they have to piggy bank. The rights of dependents against the scheme are based upon the rights of the principal member and may not exceed the principal member's right. They cannot, dependents don't have more rights than the main member or the principal member. They've got the same rights, the same limits. Okay. Who can be a dependent? Now let's have a look at that. A benefit option is not a separate medical scheme. It's all in one scheme. So that you've got this scheme for this and that scheme for benefits and that for that and that. It's all one package. It is a package of benefits offered by the medical scheme to its members, and therefore a medical scheme can offer a number of different options to its members. The registrar shall not approve any benefit. He will never approve any benefit unless, here's the big word, unless the council is satisfied that such benefit option includes the prescribed benefits, tick, shall be self-supporting in terms of membership and financial performance, yet, tick, is financially sound, yes, tick, will not jeopardize the financial soundness of any existing benefit option within the scheme, and is happy, tick, and then, only then, he will register it. A dependent of a member can be an adult or a child, and Section 1 of the Act defines a dependent as the spouse or the partner. So even if you're not married, your partner, dependent children, your children, or other members of the member's immediate family, in respect of whom the member is liable for family care and support. So other members of the member's immediate family, it must be immediate family, in respect of whom that member is liable for family care and support. And that can be people like, let's say you're taking care of your brother or sister who is children. They might be deceased, or they might not be able to take care of them because they don't work. So they ask you to look after their children. So they are other members of the member's immediate family, because it's your brother or your sister's children, but you as the member is liable for family care and support. You must pay their food, you must pay their education at school, all those kind of things, education. So then they can also be, your brother or your sister's children can also be, because your brother or your sister is a direct family member. Okay. Cannot be your cousins, well, depending on the medical aid, but I know the direct ones. It cannot be a friend's children, that because that is not direct family. Also, I know some schemes will allow if it's your mother or your father that don't have any income, they stay with you. It's your direct family, and you're liable for family care and support for your mother or your father. I know some of my friends that they've put their parents, the one parent that was still alive, the other one passed away. They put his mother on his medical aid because the mother was staying with them. They had to take care of the mother, provide food and support for her, etc. Because when the father passed away, he left her with nothing. So she had to sell the little bit she had and move in with my friend, and I take care of her. So that is also possible. So yeah, that is the other family members. Any other person who, under the rules of a medical scheme, is recognized as a dependent of a member. Now we're going to look a bit later in this unit about other members, and there's a whole list of other members. Even a child that is studying, let's say, at university, that child of you is out of the house, out of school, but they're studying, so they're still dependent on you for care and support. You can also keep them on the medical aid. Apart from the reference to spouse or partner, the definition defines a dependent as dependent children or other members of the member's immediate family, in respect of whom the member is liable for family care and support. A close reading of this definition indicates that a spouse does not have to be financially dependent on the member before he or she can be accepted as a dependent. So your spouse might earn more money than you. Your spouse is not financially dependent on you. Actually, you are dependent on your spouse because the spouse is earning more money. So it doesn't that doesn't get the point is that's your spouse. So they are dependent on your medical scheme. The phrase spouse or partner can be read independently of the phrase in respect of whom the member is liable for family care and support. What I just said now. Because the law imposes a reciprocal duty of support between spouses and joint responsibilities for supporting and raising children born of the marriage. So that's why the law says spouse we can take out of the definition, because the definition say if you are responsible for family care, um, it's your spouse. Then just for the fact, even if your spouse is not financially dependent, your spouse earns more money than you. The fact that it's your spouse, that you can add them as a dependent on your medical aid. In this broad definition of a dependent, the Act recognizes that families come in different shapes and sizes, and the definition of the family changes as social practices and tradition change. So, as time goes by and traditions change, social practices change, this definition is adopting as well. It means that now same-sex partners also qualify as dependents. So if you're in a same-sex relationship, your partner can also qualify as a dependent, which was not the case a few years ago or many years ago. Adulty dependence. An adult dependent is not specifically defined in the Act. However, in the definition of a dependent, an adult dependent is defined as other members of the member's immediate family, in respect of whom the member is liable for family care or support. You see, so you must remember the moment the member is liable for family care and support, you can add that the dependence, as well as any other person who, under the rules of the scheme, is recognized as a dependent. Okay. In terms of the moral rules, which serve as a guide to medical schemes for compiling their own scheme rules and serve to clarify, to provide clarity on matters affecting the relationship of a member is regarded as the member's nearest family by way of affinity and blood, both linearly and collaterally. Okay, so the definition says it must be your nearest family or defined by blood. They must have the same blood, family blood. I know we all got red blood, but there's different types of blood. But my blood and your blood is not the same family blood. My family says our DNA, your family says your DNA, other people's families sells their own DNA. That is how they can link us as family. And that is also why uh, if somebody in my family has got some illnesses, we inherit it because it comes from the blood. And then you stuck with the same illnesses as your older family members because it's in their blood transferring to you when you are born. This means that the members' parents, brothers, and sisters, these dependents have recognized as dependents only as and when there is a duty of support in respect of them by the member. Therefore, the liability of family care and support is founded on the common law practice that there always exists. In principle, a duty of support between ascendants and descendants, such as by a child to a parent. That is why, if you've got an older parent, you can add your parent. What my friend did. Actually, two of my friends, the one's got his mother on and the other's got their father on, because the mother passed away. So yeah, you can also add your parents if they are financially supported by you. So if you've got the liability of family care and support. What is dependency? In the moral rules, dependent is as follows. In relation to a dependent, other than the member's spouse or partner, a dependent is who is not in receipt of a regular remuneration of more than the maximum social pension per month, or a child who, due to mental or physical disability, is dependent upon the member. So this is when somebody is a dependent, but they are actually not in the definition. But the point is, you must still take care of them. So it's like when they get the maximum pension per month, or a child due to mental illness as a disability, and they are dependent on the member. So a child that's 44 years old, but they've got a disability, and you must take care of them, you can keep them on the medical aid. That is why you will see so many times on carte blanche when they had stories about people suing the medical aids because they didn't want to help to pay for this disabled child that was living with them for expensive medication that will help the child. So that child was 30, 40 years old, but they were still disabled, but still on the parents' medical aid. The common law requirement for dependency is interpreted to mean the person who's the dependent who claims support must be unable to support him or herself. So that person who's the dependent, your father or your mother who's old, father or mother, who claim support. So they mustn't stay on their own and have pension and living lekker nicely. They must claim support from the government, and they must be unable to support him or herself or themselves. The moment they can support themselves and they don't claim, sorry, then you cannot add them. That is why my friends' parents, they never saved for pension, so they don't have a pension. So they claim SASA. Actually, I've got three things thinking of now. Three. They claim SASA, which is not a lot, and they're unable to support themselves. My friends have to to take care of them. That's why the parents stay with them in the flat at the back of the yard. They stay for free. They eat for free because my friend will make extra food, and so either the parent will come and eat with this family. Other time they will take the food to the parent. If the parent don't want to come to their house. Yeah, because sometimes, because I know the father is got difficult to walk. He's walking with sticks. Sometimes his knees are not. He's got pain in his knees, and then he just tell her, "Listen, please bring my food here to my house at the back. My knees are sore." Then she takes the food for him, and then they pay all his bills and he stays for free and so on. So yeah, he cannot look after himself. The person from whom support is claimed, the member, must be able to support the claimant. So yes, that's why they take care of their parents. The relationship between the member and the dependent is such to create a legally duty of support. Legally, they must take care of their parents because the parents can sue the children if they don't look after them. And I don't know if you know that. You can speak to any lawyer. If children don't look after their parents, the parents has a right to sue the children for not taking care of them on the fact that when you were children, they took care of you. And you will lose the case if your parent takes you to court. They will win. Unless you've got a very good lawyer, but I don't see that happening. This means that a person does not qualify as a dependent simply because the member applies for registration because of a decision to take care for such a person, where, in fact, that person is able to support him or herself. So that's what I said. If they're able to support themselves, sorry, the medical scheme will not accept them as a dependent. In addition, it is not a requirement that the immediate family must reside with the member to be recognized as a dependent. You see, so they don't have to stay there. If they stay in an old age home or a home or retirement village and you're paying for that, that's also, but you're paying for that. They are depending on you. Persons falling outside of this definition, such as a grandchild or parents-in-law of the member, may become dependents in terms of the definition of a dependent, namely B, any other person who, under the rules of a medical scheme, is recognized as a dependent of a member. So your parents-in-law, if they're in the same situation, you can also put them on the medical scheme. So when you look at child dependent, as previously stated, there is in law a reciprocal duty of support between spouses and joint responsibility for supporting and raising children born of marriage. A child dependent is defined in Regulation 1 of the regulations to the Act as a dependent who is under the age, and I highlighted, under the age of 21 years or older if she permitted under the rules of a medical scheme to a dependent. You see, that's why we say if your child is 24 but is still studying, they are depending on you to pay their fees at the university, to pay their pocket money, etc., for food and whatever. Studying, so then it's still fine. But the moment they finish studying and they start to work with that degree, then sorry. So further to this, the model rules provide the following guidelines definition for a child dependent. So let's look at the child dependent definitions. So a member's natural child or a stepchild or a legally adopted child. So it can be your natural child, or if you adopted, or a stepchild or a legally adopted child. So it must be legally. Mustn't just be you you took the child in but you haven't legally adopted it. Or a child in the process of being legally adopted. So, yeah, if it's in the process or a child in the process of being placed in foster care with you, or a child for whom the member has a duty of support, or a child who has been placed in the custody of the member or his or her spouse or partner, and who is not a beneficiary of any other medical scheme. Generally speaking, children over the age of 21 years can still be accepted as dependents provided there is evidence to this effect. So, for instance, for example, a child is over the age of 21 years who is studying at university and is not living independently of the principal member and has no source of regular monthly income can be accepted as a dependent, as I just explained on the previous slide. So that child might be 24, 25 years old. They are still studying for the honors or master's degrees or whatever, or for a long course. So yes, death of a member. The death of a member terminates the member's relationship or contract with the scheme, and as a result, that member's dependents are no longer beneficiaries of the scheme. So the moment the main member passes on, the scheme, the dependents has no longer can they be beneficiaries because the contract will terminate, it will end. But the rules of most schemes make provision for a transitional period. They will not tell you, oh, sorry to hear your husband passed away on the 30th, but tomorrow, the 31st, you're off medical aid. No. They'll give you a transition period. They'll tell you, listen, and it will depend from medical aid to medical aid. You've got X amount of time to look for another medical scheme and move over. So there's a transitional period so as not to prejudice the dependents, but ultimately they cannot continue to be registered as dependents indefinitely. So they will give you 3 months or 4 months or whatever they decide to move. But after this time, whatever they gave you, 3 months or 4 months, once that is passed, sorry, you're on, off. Whether you got another medical scheme or not, because they gave you warning. The dependents must either be registered as members themselves on the new scheme, if they are eligibly, unlikely in the case of a registered medical scheme, or they must become registered as dependents of another scheme member if they wish to continue as beneficiaries of that scheme. So, for instance, if you're married and you've got 3 children, but you and the children are dependent of the spouse, so you are all dependents. Now the spouse passes on, and now the medical scheme says you must move. It's fine. You, as the spouse that's left behind, you can then become a main member of a medical scheme, and your children can then join under you for as the new dependents, under you as the main member. A scheme may provide in its rules for the membership of a minor who is assisted by his parent or guardian in terms of Section 30, subsection 1 of the termination of membership. In terms of Section 29, subsection 2 of the Act, membership may be terminated by a scheme only on one of the following grounds: failure to pay within the time allowed in the medical scheme's rules the contributions required in such rules, failure to repay any debt due to the medical scheme, submission of fraudulent claims, and committing any fraudulent act, or the non-disclosure of material information. The, the most common cause of complaints or disputes is the non-closure of material information at the time of application for membership. It can be very problematic for the member and can cause financial hardship. The requirement of disclosure of material information by a prospective member of a medical scheme can only relate to those conditions of which the member is aware, as the member is not medically trained to self-diagnose. So, in other words, you must be open and declare anything that you are aware of and that you know. We all know that you're not a medical and you don't know other things that's gone wrong with it is wrong with you since you haven't been to a doctor yet. So, however, questions must also be answered accurately and truthfully by the applicant, even if the answer may seem unimportant or trivial. So, even if you don't think the answer is relevant, you must still declare it. They will decide. At least you declared it. It must also be noted that the Act makes it a criminal offence to knowingly make or cause to be made a false representation of any material fact to a medical scheme for use in determining any right to any benefit allegedly due in terms of the rules of the medical scheme regarding Section 66. So you can be held legal for conditions you haven't mentioned. So please be open to them. The rules of a medical scheme determine the benefits that must be offered by the scheme to its members and the contributions that must be paid in respect of those benefits. Schemes may offer more than one benefit option, and the different options must also be provided for in the rules of the scheme, together with the contributions payable in respect of each benefit option. A benefit option is not a separate medical scheme. It is a package of benefits offered by the medical scheme to its members. And therefore, a medical scheme can offer several different options to its members. The registrar must approve each benefit option offered by the scheme. Section 33 of the Act provides for the approval and withdrawal of benefit options, and Section 33, subsection 1 states the following: the registrar shall not approve any benefit unless the council is satisfied that such benefit options includes the prescribed benefits, shall be self-supporting in terms of membership and financial performance, is financially sound, and will not jeopardize the financial soundness of any existing benefit option within the medical scheme, as we said before. All right, you might think that these are duplicates. Yeah, in a way they are, but there's some changes. Previously, we looked at the benefits for members. Now the topic is benefits and benefit options. All right, so that's why they might be duplicate, but there's a few changes between them. So yeah, let's have a look. This provision in the Act means that the benefit option is, in effect, a scheme within a medical scheme. But one benefit option cannot cross-subsidize another, and each benefit option must be financially self-supporting. Every benefit option must, at a minimum, provide cover for the prescribed minimum benefits. If the registrar thinks that the benefit option is not financially sound, in other words, it doesn't make financial sense, it doesn't bring in money for the extra money you charge, he or she may demand from the scheme financial guarantees to ensure the financial soundness of the benefit option. These are usually in the form of bank guarantees. The accumulated funds or reserves of a medical scheme belong to the scheme itself, and it is not possible, despite the requirements of the Act, to ring-fence scheme funds for a particular option. Alternatively, the registrar may withdraw the approval of that benefits option, and the medical scheme then has to amend its rules accordingly, with effect from the date directed by the notice by the registrar. If the registrar does this, the scheme will have to arrange for the members that are on that benefit options to be transferred to another one of the scheme's options. In this instance, the rights of the members can be quite significantly affected, and for this reason, a decision to withdraw benefit options is usually taken at the end of the scheme's financial year, so that affected members can make alternative arrangements for the new benefit year. Regulation 4, subsection 2 of the regulations to the Act provides that where a medical scheme offers more than one benefit option, it may not prevent any member from choosing or deny any member the right to participate in any benefit option offered by the medical scheme, provided that a member or a dependent shall have the right to participate in only one benefit option at a time. Furthermore, in terms of Regulation 4, subsection 3, a medical scheme may, in its rules, provide that a member may only change to any benefit option at the beginning of January each year and by giving written notice of at least 3 months before such change is made. So by October, they need to give you notice that this is the new benefit options, this is the new prices for the next year. You've got 3 months to make up your minds, as from January, uh, the 1st of January the next year, you must make up your mind for the new benefit options and packages for the next year. Okay. So when you look at personal medical savings account, um, as most of you know, you've got like maybe a hospital cover, and then you add personal savings, or you've got a medical account. You pay so much, and they pay for that benefits, but you can add a savings account where you put extra money in. Regulation 10 of the Regulations to the Act defines the characteristics of a personal medical savings account, the PMSA, to include the following. A. The limit on contributions into a PMSA must not exceed 25% of the total gross contribution made during the scheme's financial year, and that's Regulation 10, subsection 1. And why did they put that rule in? Can anyone tell me? Okay, I hear nothing. Let me tell you. So, in the past, this was not there, so it was unlimited. Many years ago, unlimited. I think it was early 80s, 90s, 2000s. So this amount was unlimited. And this is not, I don't know if it's still, but it was not taxable. And that was the problem. So now the guy's premium, his monthly premium at this medical scheme was 2,000 Rand a month. But then he add in his savings account, the big businessman's 50,000 a month. 12 months in the year, so they put in 600,000 Rand a month in the medical savings account. Why? No tax. And because this 600,000 was not in their bank accounts, they didn't have to pay tax because it was in a medical savings account and there was no tax. You see what they've done. Then they said, I've got 600,000. No, I've got 600,000 Rand for my savings for medical bills. You know what? That was the reason. In case in emergency and the medical, I don't want to pay, I've got money. And then the SARS says, oh, no, this is a problem. This is a big problem. He's paying 2,000 Rand a month for his medical scheme, but he's putting 50,000 Rand a month from the business money in that savings account. So now he's not paying taxes on 600,000 Rand. And if that is 2 years in a row, it's 1.2 million Rand he put in, because next year he puts another 600 or more. So they couldn't tax, SARS couldn't tax on it. So that is why SARS says, no. This is not going to work anymore. This needs to stop ASAP. So now you can only pay 25% of your monthly premium. So if your monthly premium is 2,000, what is 25%? That will be 500 Rand. That's your maximum. You can put in your savings. can only put 25% of your monthly premium. So yeah, so that is the reason. Okay. So B, the limit on contributions applies to each individual member of a medical scheme, Regulation 10, subsection 2. So there's limits on the contributions. See, the funds in a member's PMSA may be used by that member and that member's dependents only. Only they that can use it, the member and the dependents. They may not be used to offset contributions. In other words, you cannot say, tell them, okay, I saved so many years, I've got 10,000, please take my contributions from this money. No. Or you cannot use them to offset debts owed by that member at the date of termination of membership. Oh, sorry, they may be used. You cannot use them. They may not be used to pay contributions, but they may be used to offset debts owed by that member at the end of termination date of membership regarding Regulation 10, subsection 3. So if you owe the medical aid anything and you terminate it, there's money in your savings account, they can take that money to pay your debts, and then they'll pay you out the balance if there's anything left. D, the credit balances in a member's PMSA are never forfeited. So if you've got a positive, let's say you've got 1,500 Rand in your personal medical savings account, it will always stay there. You will never lose it. The credit balances are transferred to the new medical scheme or to a benefit option within the medical scheme's account MSA regarding Regulation 10, subsection 4. Not the medical savings account, the MSA. So you've got 1,500 and positive credit balance. You terminate your agreement with your medical scheme. You get a new medical scheme, and you can tell them to transfer that money to that new medical scheme, and then you start immediately with that money. So it's not anymore at the old one because you terminated that money, they transfer to the new medical scheme. The credit balances are refunded to the member in cash where membership of a medical scheme or benefit option is terminated, or where membership is replaced with membership of a medical scheme or benefit option without a personal medical savings account. So if you move to another medical scheme and you don't have a savings account, no savings, then they will give that money. You'll still get that money, but now you will not get it in a savings account, you will get it in cash. Then you can put some petrol in your car for the month. And that is according to Regulation 10, subsection 5. No part of the funds in a PMSA may be used to pay for the costs of prescribed minimum benefits, and that's according to Regulation 10, subsection 6. So they may not use your savings to pay for prescribed medical benefits. The Council for Medical Schemes issued a circular in 2013 noting that some medical schemes had been paying for prescribed minimum benefits out of members' personal medical savings accounts, and that this is illegal. It is illegal in terms of the regulations under the Medical Schemes Act, the MSA. It also noted that some schemes are refusing to pay for appliances and medicines needed by the patient on discharge from hospital, and reminded schemes that the legal provisions for the treatment of PMB conditions include all aspects of care. So they cannot say, no, we're only going to pay for the medicine but not for the machines needed. No, all aspects needs to be paid. For instance, acute and chronic medications, medical and surgical supplies, and in and out of hospital care. It's just amongst other things that needs to be paid. Schemes were advised that complaints by beneficiaries in respect of these matters will be treated by the Council for Medical Schemes as valuations of the Medical Schemes Act. So if you've got an issue or a problem with that, please take it to the Council for Medical Schemes Act and sort it out with them. It is important to ensure complete compliance with the Act on these aspects of medical scheme benefits because the persons involved in the non-compliance, such as the Board of Trustees of the scheme, can be criminally charged in terms of Section 66 of the Act with an offence and are liable on conviction to a fine or to imprisonment for a period of up to 5 years or both. All right, so that is the fine they're looking at. They can get a conviction where they go to jail for 5 years, up to 5 years. It can be less, or they can get a fine, or they can get both the fine and up to 5 years in prison. The question of who owns the fund in the medical scheme savings account was decided by the Transvaal Provincial Division in Ledwaba. Now, people, I just want to say one thing regarding the previous slide. If I go back, the Council for Medical Schemes said that has noted that medical schemes had been paying for prescribed minimum benefits out of the member's personal medical savings account and that this is illegal. I phoned my medical scheme broker and I tell him, but why have I been paying for my prescribed minimum benefits out of my savings account? Because it's illegal. And he said, wait, Jaco, it's not. You choose that option to have state chronic the day we decided, and you said no. Because I don't want to drive into city to go to the government hospital, sit there for a few hours every day to collect my medicine. I don't have time for that. You said you want a savings account, which made your option cheaper. Because now they don't have to pay, the medical aid don't have to pay for your medicine. Option, a cheaper option. So now my premiums are lower. So he had records of what we discussed, and I remembered, oh yes, now I remember. He said, if I don't take this one, I choose another one. I think I choose core, if I remember correctly. That was the cheaper one. But that one was fitting for me. I don't need anything more. So if I choose the state chronic, what will happen then? I will pay more monthly. Problem number one for me. And problem number two is sit in queues to get my medicine, to get PMBs. So yes, they will give it to me. But then I must move from my core plan. I must move from my lower premiums to the state chronic plan, and I'm gonna pay more every month, and I must go and sit in queues to get my PMBs. He said, and that's why he said, no, you rather go the savings route. And I remembered, yeah, okay, sorry, you were right. So please don't rush and make a big scene. Decide for yourself. Do you want to pay more every month and go and sit in queues to get your medicine? Or do you want the lower premium and to have a savings account and pay your medicines? Because now I just go to Clicks or this scheme. Go in there, yeah, you stand in the queue, but not for as long as in the state hospital. Maybe a few minutes, get my medicine, and then I go. So yeah, just make sure of that. before. Everybody's making a big fuss, and that is the end of part 4. I will see you in the next part, and you know what to do if you've got any more questions.